want to just thank the RAC Summit for awesome opportunity to be with you. Day and Justin, you and your team have done a tremendous job just putting this together. We're often spoiled when we go to events like this because we just show up and everything is done, but we don't realize the tremendous amount of work that's put into them. So we do appreciate being a part of this amazing event. One housekeeping item, please link up with me on LinkedIn. I'll be placing post-conference training tools that engage, that highlight what we've talked about today, and also speak about the fight that we have ongoing with CMS as well. Heard a great story of a woman who took her husband to the doctor, and the doctor told her, if you don't do these three things, your husband's going to die. Number one, you need to make sure you eliminate all stress in his life. No household chores, no nagging, no accusing him of anything. You need to eliminate all arguing in his life. Number two, I need you to make sure that every day after you finish working 8 hours, you give him a nice home-cooked meal. Whatever he wants, you make sure you prepare it for him. It's timely so that when he gets home, he has the ability to consume it timely and get to bed. If you don't do these three things, he's going to die. Number three, give him whatever he wants. The sky is the limit. Satisfy his absolute every whim. And so they're driving back home, and the husband asked the wife, well, what did the doctor say? She said, you're going to die. How do you respond to pressure? How do you respond to things that are bigger than you? No matter what state you are in, there will be giants. And you know who they are. They're the ones that hijack your revenue cycle and send you those ransom notes called EOBs. Give me medical records or give me hard copy authorizations, and then I'll release your money. And it's the giants in the industry that tend to make us ignore data or ignore certain denials. They intimidate us into thinking that no one can fight them. They're too big. They're too strong. No one in my organization has ever overcome this type of denial. But this morning, we've come to help slay that giant in your life. We've come to show you how to advocate for medically appropriate health care according to a case called Wickline versus State. Please write that down, Wickline versus State. In the case of Wickline versus State, Lois Wickline was cleared for an abdominal aorta surgery. Her treating doctor wanted to observe her condition for an additional 8 days. Medi-Cal would only grant 4 days. The doctor released her after 4 days out of fear of retaliation or of not being paid. She suffered an infection in her leg, and in 1977, they rushed her to the hospital to amputate that leg, or she would have died. She sued some people. She sued the entire state of California and the doctor. Who do you think she won against? She won against the doctor. In the court decision, the courts concluded that Medi-Cal was not responsible for the discharge decision. And from that case, many states adopted or followed California's Business and Professions Code 510 to adopt legislation that mandated that you, as a practitioner or a physician or provider, advocate for medically appropriate care for your patients. And it means this under the law. Number one, to appeal a payer's decision pursuant to their appeal or grievance procedure. And number two, to protest and challenge any practice, policy, or procedure that impairs your ability to provide appropriate care to your patients. That's why we're here this morning in this conference, because justice has a sound, your sound, and the purpose of the law is to bring you to a place of recovery. Just repeat this with me. I advocate for medically appropriate health care for citizens in my state. What does that mean? Let's discuss it. 3 things Medicare Advantage plans don't want you to know. Number one, the Freedom of Information Act. I love what Kurt said yesterday. After 4 years of college, 4 years of medical school, 3 to 7 more years of training, insurance companies tend to control the fees of the physician or provider. But who controls their fees? No one gets to pay 50% of the health premium and say, I'm sorry, your premium was above usual and customary. Oftentimes, plans make decisions to pay certain claims, and we have no idea how they've arrived at that rate. No idea why they initiated a refund or recoupment. No idea what legal or clinical rationale they relied upon for their decision. As advocates, we have a right to demand substantiation of a payer's action or inaction. Here's simply a case study that you're looking at where we heard from Humana, and Humana was promising to reimburse a payment, and we were simply asking for the payment details. And Humana responded, due to HIPAA laws, I cannot send you an EOB. I can confirm the claim was processed and paid on 3/23/17. Check with the provider to ensure that they got it. So we simply wrote this. Ms. Cundiff, please provide the HIPAA privacy rule you rely upon that prohibits you from sending the EOB to a business associate of a covered entity. Well, she responded shortly, I sent you a copy of the EOB on 3/28 via secure email. But the question is, why did she take us through that? Likewise, under the Freedom of Information Act, we have the ability to request any agency record. We file regulatory complaints against CMS against MA plans that tend to violate Part 422 of the Medicare Act or rule. And we don't always put our eggs in the ALJ pot for that reason. Every CMS region office has an account manager over their plans, and they have to log your complaints into something called a complaint tracking module. Well, we had one CMS region manager that stated, we don't accept complaints from a contracted provider because it is CMS's rule not to get involved if there is an existing contract. So what did we do? We wrote a Freedom of Information Act, and we were asking for any agency record, any CMS policy or SOP that outlined how CMS would handle complaints from any member of the public, whether contracted as a provider or not. Because we recognize that under 422, 0.504 of 42 CFR, there are rules that an MA plan has to abide by in their contract with CMS. So CMS provided us with their standard operating procedure that outlines that you, as a contracted provider, can indeed file complaints with CMS, and they have an obligation to oversee resolution of that to ensure the plan is acting consistent with their agreement. And so this type of FOIA is very effective because it gives you the ability to request anything that you immediately question. We also realize that a second thing that Medicare Advantage plans don't want you to know are the time frames to authorize post-stabilization services and care. Here's a great law you can write down. 42 CFR 422.113 B2 states that the MA organization is financially responsible for emergency and urgently needed services, regardless of whether they're provided outside the MA organization, also regardless of whether there is a prior authorization for the services. Notice the physician treating the enrollee determines if the patient is stable, not Kaiser, not another payer. Your doctor determines when the patient is stable for discharge or transfer. We also realize under Section C2 that the MA plan is financially responsible for post-stabilization services obtained within or outside the MA organization that are pre-approved by the plan. So whatever they authorize, they must pay for. Also, notice they're financially responsible for post-stabilization services that are obtained by a plan, within or outside the MA organization by a plan provider, watch this, but administered to maintain the enrollee's stabilized condition within 1 hour of your request. So a patient comes through the ER, you then want to admit them, you have to call for an authorization. Oftentimes, in this authorization process, it takes a while to hear back from the MA plan. They will even issue you something called a tracking or a reference number. Even though the law states they must issue a pre-approval or an authorization, they will give you a tracking or reference number. Why? Write this down. Because an authorization creates a contract, and they're attempting to preserve their ability to conduct a retrospective medical review after the patient is gone. So notice the law states once you make that phone call, whatever you administer within 1 hour, it is a deemed authorized service until you hear back from them. Next section says this: they're financially responsible for post-state care obtained by or outside the organization that are not pre-approved, but administered to maintain, improve, or resolve that enrollee's stabilized condition. Watch this. If the MA organization does not respond to the request within 1 hour, or they cannot be contacted. So what that means is every time we call and we can document contact was made. What's the purpose of the tracking and reference number? If it's not an authorization, it constitutes that contact was made, you knew the patient was here, and you did nothing. Every time we do that and they fail to respond within 1 hour, we call on the 15th, we do clinicals on the 16th, the 17th, the 18th, and the 19th, and the 20th, they're discharged, and we've heard nothing. The services under existing Medicare law are deemed authorized. No medical records, no medical records review. It is a deemed authorized service. Watch this. I love this section here. It states the end of the MA plans a financial responsibility for services they've not pre-approved. Here's when it ends. Number one, when a plan physician with privileges at your hospital assumes responsibility for the care. Number two, when a plan physician assumes responsibility through transfer. Number three, when there's an agreement reached between the MA plan and your treating doctor. But look at four, because four is what happens the most. When the enrollee is what? If they come in, we notify you, we give you an opportunity to assume care for the patient, and you do nothing until the patient is gone. Your financial responsibility ended on the day of discharge. Don't you call me the day after or a week after asking for medical records. You had that opportunity when I initially contacted you. When you failed to respond within 1 hour. We had a case here similar that was denied by your favorite payer, UHC, and they denied it for readmission reasons. Notice in this scenario, we're looking not to challenge a readmission reason or denial with medical records, but we're looking to challenge it, looking back to see, did we make contact? It was a $500,000 claim. Notice on the timeline, on 6/7/13, UHC issued an authorization. On 9/10, they stated that the claim was denied pending medical records. What was wrong with that? On 6/7/13, they had already issued an authorization or pre-approval. On 9/10, the hospital, unaware of their rights, issues by certified mail medical records. On 12/10, UHC denied it for medical necessity. Write this down. If you obtain an authorization, do not set a precedent by giving them medical records for previously authorized services. You open the door for them to deny it for medical necessity reasons. We then saw in the timeline that on 2/4/14, the hospital does an oral appeal. On 2/18/14, it's denied again for readmission reasons. On 4/2/14, the hospital sends 2 boxes of medical records for another medical review. On 5/27, that denial was upheld. But I want you to see this. This is quite interesting. As you look at what happened, you'll see that in our letter, one of our attorneys just began to break down what really took place in this case. And they wrote, as the evidence will prove, Secure Horizons denied the claim on 8/29/2013. On 9/10, Memorial sent an appeal with medical records to Secure requesting reconsideration. When Secure received the medical records with the cover letter, if they needed clarification, if the request was for reconsideration, they could have sought to do that. Instead, they conducted a reconsideration, and at the time that they upheld that denial, they did not immediately send the case to the independent review entity pursuant to 422.590. Furthermore, she writes, patient was admitted through the ER. Memorial was given authorization by Secure to admit the patient. Pursuant to 422.113, an MA organization is financially responsible for emergency and urgently needed care, whether there is a prior auth. However, since there was an authorization given in this case, per federal law, the MA organization is also financially responsible for what they have pre-approved. She then writes, therefore, United is liable for the entire amount. The authorization demonstrates that UHC was aware of the admission. Even if they did not issue an authorization, they were given an opportunity to assume care through a planned physician who has treating privileges at their hospital, through a planned physician, through transfer, by reaching an agreement with the actual treating doctor. Since that did not occur, their financial responsibility ended upon patient discharge. Now, this is quite interesting because I remember I really enjoyed Mr. Gorman when he spoke earlier, and he was stating a few things that really stood out to me. Number one, MA plans are rethinking the authorization process. They want to do less of what pisses providers off. Well, as long as 42 CFR 422.113 exists, you cannot admit patients without making contact. That law protects you in the event the plan does not respond within 60 minutes or 1 hour. Number two, he mentioned that risk adjustments and star ratings is what the plans care about, and risk adjustment means more medical record requests. All right, so here's the question. When you get that medical records request, you have to go back to Genesis, go back to the beginning. How did the patient get here? Patient arrived with severe crushing chest pains. Was the plan notified of the admission with the request for pre-approval? Did they approve care or fail to respond within 1 hour? If they have failed to respond within 1 hour and the enrollee has been discharged, the services are statutorily deemed authorized. So here's what's happening. Every time someone sees a medical necessity denial in your office, more than likely they're rushing to get medical records. Not anymore. Now we're going to find out, was the plan contacted? Did they fail to respond within what? 1 hour. If they failed to respond and the patient is gone, they did not disapprove care while the patient was still in-house, it is deemed authorized. Mr. Blue Cross, your request for medical records is denied. This claim has been statutorily deemed authorized because on the 15th of January, contact was made, clinicals were sent 4 days in a row. You said absolutely nothing. Patient was discharged, which deemed the stay authorized. You're financially responsible. If you disagree, please provide the statutory authority you rely upon to request medical records for statutorily deemed authorized services in light of this section of law. And you're going to hear the most awkward stretch of silence when you request that. And so our objective was to challenge UHC in this issue. CMS then responded. Notice here, they responded and stated this to us. Thank you for your continued patience. It does appear based on the information you provided and additional details from United, they should have addressed this matter back in September 2013. We will allow them to now follow through. They have the waiver of liability. Notice in the next slide, you'll see that they decided on August 14th, 2 weeks later, they said this: we received your request for an appeal July 8th, 2014, about the denial of inpatient claim for services provided at Memorial, June 6th through July 19th, 13. Thank you for bringing this to our attention. We will pay for those dates of services. Watch this, based on the records. What records? Because they were supplied twice before. You denied it twice before. We provided no records because you had already authorized the services, and to us, it was an improper denial in the first place. But they said, based on the records, there was documentation of adequate treatment during the first admission and stability at discharge. The readmission is not related directly to the first admission. The readmission denial has been overturned. We'll pay you in 60 days. Now, this was a $500,000 claim. We could have, most people would have seen that and said, we're really excited. They're slapping high fives. They're going to get coffee. And the case is done. Let's get to the next one. But that would be no fun, right? We're concerned about the fact that they're saying, wait 60 days. We've already been waiting over a year in this scenario. So we then wrote to CMS and said, we thank UHC for their partial compliance. But we have an issue because under existing federal law, Medicare Advantage plans have 60 days to effectuate a reconsidered determination. We talked about all the time frames they had failed to do so. She wrote back and said, listen, I appreciate you sharing everything you've shared. We will address UHC's improper handling of this matter, but such actions will not include instructing them to pay you earlier than another 60 days. If they don't pay you in 60 days, let me know. Now, we could have said, well, we've filed the complaint with the agency. They've already made their decision. $500,000 of a claim that's been denied has been overturned. Let's go to the next case, but that would be no fun, right? So we then wrote to her boss and said, hey, we have a problem with your regional office's ability to provide aggressive oversight over their Medicare Advantage plans. Below, you will see a glaring issue that we want to bring to your attention of them attempting to permit a plan beyond 60 days to effectuate a reconsidered determination. As of right now, this claim is now 349 days beyond the statutory time frame for reimbursing claims. Please order your MA plan to reimburse the claim. If you fail to do so, we would appreciate an electronic written copy of any CMS manual, handbook, standard operating procedure, or statutory authority that permits Medicare Advantage plans to pay reconsidered determination decisions beyond 60 days when they originally obtained it. We then got an email about 5 days later, Mr. Norwood, Memorial can anticipate payment by the end of next week. And so they don't want you to understand what your rights are in this context. And so we spoke earlier about how we have a job or we have a duty to advocate for medically appropriate health care. Lastly, Medicare improper use of traditional Medicare look-back period. We've been challenging this quite a bit, and recently we got this letter that you're looking at from WellCare. And they stated below near the arrow, based on the above federal statutes, WellCare follows CMS guidelines on recoupments pursuant to, write this down, 42 CFR 405, 350 to 379. Further, in reviewing the letter of agreement entered into by Baxter, your provider member, in 2008, I see no reference to audit rights. The documentation on overpayments should have already been sent to them with an explanation of why we're recouping it. And our issue in this case was WellCare had sent a spreadsheet requesting recoupments or refunds on close to 100 patients. And there was no explanation as to why they were wanting that money back. And so she writes here to us that she's relying on Section 405. Keep in mind that the Medicare Advantage plan is run or governed by 42 CFR 422, Part 422. That was an immediate red flag for us. We wrote then to her and simply stated this at the bottom in bold: please provide the specific section of 405.350 that delineates a recoupment process for Medicare Advantage plans and their providers. Also, please provide the statutory authority that WellCare, a Medicare Advantage plan, relies upon to conduct a recoupment under that section of law, which applies to Medicare Part A and Part B service providers. Lastly, the statutory authority you rely upon to claim a definition as a Medicare contractor. We then wrote to her from the legislative intent that created some of the laws she was referencing, supporting the recoupment efforts. And in the Federal Register there, listed in bold, here's what they stated. Commenters stated that CMS did not articulate any statutory authority or rationale for creating this distinction and narrowing the scope of the proposed rule to Medicare Part A and Part B providers. According to commenters, the Medicare payment rules do not create any analytically distinct issues for Part A and Part B providers and suppliers over other categories of persons, as defined by the rule. Thus, commenters believed the rule should similarly be applied to all categories of persons as they relate to Medicare. Commenters noted that many providers or suppliers who submit claims to Medicare A and B also submit claims to Part C Medicare Advantage. And they simply wrote this in the Federal Register. We appreciate commenters' concerns, but will finalize this 6-year look-back rule as proposed to apply to Medicare Part A and B only. And so we provided that to WellCare at the time and spoke about some of the concerns that we had about the recoupment. And as you can see on the next slide here, we heard back from the provider about maybe 20 days later. And she wrote this: I have went through many of these cases and found that they were not an appeal, cannot find notification by WellCare of a denial or notice why they were recouping. We had reached out to our old rep and was told that when WellCare does their recoupments on a remit, they do not tell providers which accounts they are recouping from to pay. Instead, she said she can send us an F status report. Make a long story short, she said this next to the blue arrow: I think you have scared the daylights out of WellCare because they are now repaying us money on several of these accounts on the last 2 remittances. Later, the CFO or director stated this to us: thank you for your help. WellCare was driving us crazy. There are payers that are driving you crazy. And I simply came here to remind you, you are not powerless to initiate change in this healthcare delivery system. If you do not challenge your system, you cannot change your system. You have a responsibility to ensure that you advocate for medically appropriate healthcare. That means we make a decision to be 1,000 times more than what our title is. 1,000 times more than what our biggest overturn has been. 1,000 times more than what our status indicates in the industry. Because your patients deserve the very best from you. Thank you.